Venezuela, a country once celebrated for its vast oil reserves and economic promise, has become the epicenter of a global financial and legal storm. With an estimated $3 trillion in untapped oil and mineral resources, it is no wonder that governments, multinational corporations, and billionaires are all circling the South American nation with a mix of greed, fear, and legal caution. What makes Venezuela's situation uniquely volatile, however, is not just the scale of its natural wealth, but the complexity of its legal entanglements. Contracts that span decades, sanctions imposed by foreign powers, disputed ownership of oil fields, and the murky waters of international law have all combined to turn the country into a labyrinth that could trap anyone who attempts to intervene without careful planning. At the heart of this legal quagmire lies the Venezuelan government itself. After decades of political turbulence, corruption, and economic mismanagement, the country's institutions are weak and often contradictory. National oil company PDVSA, historically a jewel of Venezuela's economy, has been at the center of countless legal disputes, both domestically and internationally. Creditors, foreign investors, and suppliers have been caught in a web of lawsuits, sanctions, and threats of asset seizures. Any new agreement or foreign investment must navigate a minefield of past obligations, ongoing litigation, and the constant risk of political upheaval. For corporations accustomed to predictable markets, Venezuela represents a profound uncertainty, where the legal consequences of a single misstep can be catastrophic. International sanctions have added another layer of complication. The United States, European Union, and other countries have placed restrictions on financial dealings with Venezuela, citing human rights violations, corruption, and the erosion of democratic institutions. While these sanctions are meant to exert political pressure, they inadvertently complicate legitimate business operations, creating ambiguity over what is legally permissible. Companies attempting to invest in Venezuela's oil or mineral sectors must obtain licenses, navigate regulatory approvals, and ensure compliance with multiple jurisdictions. A contract signed today may become null and void tomorrow if the political climate shifts, creating a continuous cycle of legal uncertainty. The result is a scenario where even the most cautious and well-funded investors risk becoming entangled in lawsuits or sanctions violations. The legal disputes extend beyond the country's borders. International arbitration cases are already underway in cities like London, Washington, and The Hague, involving both state actors and private corporations. These cases often hinge on questions of sovereignty, contract enforceability, and the legitimacy of government decrees. When billions of dollars are at stake, these legal battles are far from abstract. They are intensely real, shaping the global oil market, investment patterns, and geopolitical alignments. Lawyers specializing in international trade, oil law, and corporate litigation have become some of the most sought-after advisors in the world, underscoring the high stakes involved. The sheer volume of pending cases creates a bottleneck, making timely resolution nearly impossible and further amplifying the risk of foreign entities being caught in prolonged legal limbo. Adding to the complexity is the involvement of foreign governments, which see Venezuela's resources as both a prize and a potential liability. The United States has historically sought to limit Russian and Chinese influence in the region, while China and Russia have invested heavily in Venezuela's energy and mining sectors. Every intervention, whether through diplomatic channels, sanctions, or trade agreements, carries legal consequences that ripple across multiple jurisdictions. A state-backed loan or resource deal can trigger claims in international courts or lead to retaliatory sanctions, creating a tangled web where legal, financial, and political stakes are inseparable. For multinationals operating in this environment, navigating these layers is not optional. It is the very difference between profit and disaster. Then there is the issue of Venezuela's internal debt. The country has borrowed heavily from international banks, private investors, and foreign governments, often using oil reserves as collateral. These debts are not only massive, but also disputed, with questions about legitimacy, repayment schedules, and default clauses. Any attempt by foreign entities to claim Venezuelan assets risks igniting lawsuits or triggering defaults that cascade through global financial markets. In short, Venezuela is a legal tinderbox. One wrong move can ignite a chain reaction affecting investors, governments, and ordinary citizens alike. Understanding the fine print of these agreements is not just prudent, it is essential for survival in this high-stakes environment. Another layer of risk comes from Venezuela's historical nationalization policies. Over the past 2 decades, successive governments have seized control of industries ranging from oil to telecommunications, often without adequate compensation. While some of these actions were justified by domestic law, they frequently clash with international legal standards, leading to protracted litigation. Companies that once held Venezuelan assets are now embroiled in multi-year arbitration cases, seeking restitution in courts far from Caracas. This creates a chilling effect on foreign investment. The very policies meant to protect domestic resources inadvertently create a global legal maze, deterring the capital and expertise Venezuela so desperately needs. The consequences of misreading Venezuela's legal landscape are not theoretical. In the last decade alone, several high-profile investors and state actors have lost billions due to contested contracts, sudden policy changes, and sanctions violations. Lawsuits that began over minor contractual ambiguities have ballooned into multi-billion-dollar claims, dragging participants into years of court proceedings across multiple countries. Even governments that attempt to intervene face legal hurdles, as any action can be challenged in international tribunals or domestic courts by aggrieved parties. This is the essence of the $3 trillion trap. Enormous wealth is available, but accessing it carries a level of legal and political risk that few nations or corporations are fully equipped to handle. At the center of this maelstrom is the human element. Lawyers, financiers, government officials, and corporate executives must all operate under intense pressure, knowing that a misstep could have cascading consequences. Decisions are not merely financial, they are political, ethical, and legal. The interplay between local laws, international norms, and the interests of powerful stakeholders creates an environment where certainty is a luxury and caution is mandatory. Misjudging even one clause in a contract, or failing to anticipate a regulatory shift, could transform a promising venture into a years-long legal nightmare. This is not a hypothetical scenario. It is the reality confronting anyone attempting to navigate Venezuela's labyrinthine legal and financial ecosystem. As the world's attention turns to Venezuela, the stakes for legal and financial entanglements become even more apparent. Part 2 delves deeper into the geopolitical and economic factors that transform Venezuela from a nation rich in resources to a high-risk legal arena. The first layer of complexity arises from the overlapping claims over Venezuela's energy and mineral wealth. Multinational corporations are eager to secure contracts, yet these agreements are fraught with uncertainty. Many contracts signed decades ago remain under dispute, often with competing interpretations between domestic law and international standards. In some cases, governments or state-owned entities assert ownership over assets that investors assumed were legally theirs, creating disputes that can take years to resolve in international courts. For any entity seeking to tap into Venezuela's $3 trillion resource reservoir, the legal hurdles are immediate, costly, and unavoidable. One major area of concern is the oil sector, which dominates Venezuela's economy. PDVSA, the national oil company, has been at the center of numerous legal controversies due to debt defaults, joint venture disputes, and contract breaches. International partners often face lawsuits and arbitration claims if contractual obligations are not met precisely according to the terms, which are frequently subject to reinterpretation by Venezuelan authorities. Moreover, sanctions imposed by the United States and other global powers create an additional layer of risk. Even small deviations in compliance could trigger penalties, freezing of assets, or lawsuits in multiple jurisdictions. The result is a delicate balancing act for any foreign investor pursuing profitable oil contracts while ensuring absolute legal compliance across local and international laws. Beyond oil, Venezuela's vast mineral wealth is attracting global attention. Lithium, rare earth minerals, and gold are in high demand due to technological advances and the push for renewable energy. However, mineral extraction is heavily regulated, and ownership rights are often unclear. Some mining concessions date back to colonial-era legislation, while others were issued under modern decrees. Legal ambiguity reigns supreme, and foreign companies must navigate a tangled web of licenses, environmental regulations, and local community agreements. Additionally, the state reserves the right to nationalize operations at its discretion, a power that has been exercised repeatedly in the past. This means that even a fully compliant mining operation can be subject to sudden seizure or renegotiation, often sparking years of litigation abroad. Political instability amplifies the legal risks. Venezuela has experienced decades of internal unrest, with frequent changes in government policies and administrative structures. Each political shift has the potential to alter the legal landscape dramatically. Lawsuits and arbitration cases can be stalled indefinitely if courts are reorganized or if regulations are suddenly amended. Investors cannot rely solely on current legal frameworks. They must anticipate future changes that may render contracts void or unenforceable. This unpredictability is a defining feature of Venezuela's business environment and one of the reasons why international legal experts caution against hasty investment decisions. The country's resources are undeniably valuable, but accessing them without triggering complex legal battles is far from straightforward. International actors also play a pivotal role in complicating Venezuela's legal environment. The presence of major global powers such as the United States, China, and Russia in Venezuelan affairs introduces a host of diplomatic and legal challenges. U.S. sanctions, for instance, are designed to pressure Venezuela's government, but simultaneously restrict private entities from engaging in energy and financial transactions without extensive approvals. Chinese and Russian investments, often secured through state-to-state agreements, are similarly fraught with risks. Any breach, even if minor, can lead to litigation, asset freezes, or retaliatory measures, placing foreign companies in a precarious legal position. The intertwining of state interests and private contracts creates a legal battlefield where miscalculations can have far-reaching consequences. Debt obligations further exacerbate the situation. Venezuela has borrowed heavily from both international banks and sovereign lenders, frequently using oil reserves as collateral. These loans carry complex legal clauses that dictate repayment, interest, and remedies in the event of default. Disputes over these debts have already led to numerous lawsuits in foreign jurisdictions, some of which involve multi-billion-dollar claims. A single misstep in honoring or restructuring a debt could trigger cascading effects, leading to legal claims across multiple countries. In many ways, the $3 trillion in resources represents not just opportunity, but a highly entangled web of liabilities that could ensnare investors, governments, and financial institutions alike. Human rights and environmental regulations add another layer of complexity. International organizations and activist groups closely monitor Venezuela's extraction practices, often challenging projects in courts around the world. Allegations of environmental degradation, forced labor, or violations of local community rights can result in lawsuits that span jurisdictions. Companies operating in Venezuela must therefore not only comply with domestic law, but also anticipate scrutiny from international legal bodies and human rights organizations. Failure to do so can trigger litigation, sanctions, or reputational damage, making legal compliance a multidimensional challenge that goes far beyond conventional corporate law. Corporate structures themselves must be carefully designed to navigate this labyrinth. Many companies establish subsidiaries in neutral countries to manage risk, create contractual buffers, or facilitate arbitration in favorable jurisdictions. Legal experts often recommend multi-tiered agreements, extensive compliance programs, and robust dispute resolution clauses. These structures are intended to mitigate exposure, but they also introduce additional complexity and cost. Even with meticulous planning, the Venezuelan legal landscape remains unpredictable. Courts can reinterpret contracts, governments can impose new regulations, and sanctions can shift without notice, creating an ongoing legal chess game where only the most strategic players can hope to avoid costly missteps. The interplay between law, finance, and politics becomes especially acute when disputes reach international arbitration. Cases often involve intricate arguments about sovereignty, contractual interpretation, and the legitimacy of government actions. Arbitration panels can issue rulings that have global ramifications, affecting markets, investment patterns, and diplomatic relations. The decisions are binding, but enforcement can be challenging, especially when a state refuses to comply. This tension between national authority and international legal standards ensures that Venezuela, U.S. resource wealth cannot be accessed without significant legal planning and expertise. Each move, each negotiation, carries weighty implications that ripple across borders. Finally, the human cost of Venezuela's legal trap cannot be ignored. Ordinary citizens often bear the brunt of litigation and economic disruption. Job losses, inflation, and scarcity of essential goods are common consequences when international investments are frozen or contested. While global headlines focus on billion-dollar deals, the local population experiences the legal fallout directly. This human dimension underscores the importance of legal precision and ethical responsibility. Stakeholders who navigate Venezuela's $3 trillion resource landscape must account not only for profits and losses, but also for the broader social impact of their actions, adding yet another layer to an already complex legal puzzle. Venezuela's $3 trillion resource wealth has attracted attention not only from investors and corporations, but also from legal experts who warn that the country represents one of the most complex litigation landscapes in the modern world. Unlike conventional markets where contracts are clear and regulatory frameworks are stable, Venezuela's environment is defined by overlapping jurisdictions, political volatility, and a history of unilateral government action. Any effort to extract oil, minerals, or other assets must therefore consider not only immediate economic feasibility, but also the labyrinthine legal consequences that may arise years down the line. In practice, this means that the financial allure of Venezuela's resources is inseparable from its legal hazards. Those who ignore this reality risk catastrophic losses. The oil sector remains the primary focus for both foreign and domestic stakeholders. PDVSA, the national oil company, controls the majority of Venezuela's oil production, yet its operations have been consistently entangled in legal disputes. Contracts signed with international partners are often challenged or reinterpreted based on domestic decrees, with arbitration cases pending in multiple countries simultaneously. Foreign corporations attempting joint ventures must navigate a web of compliance obligations, sanctions, and historical debt claims. A single contractual misstep could trigger lawsuits, asset seizures, or prolonged arbitration, effectively nullifying years of investment. This duality, potential for enormous profit paired with the risk of protracted legal battles, is at the core of Venezuela, a $3 trillion trap. Mineral resources, especially lithium, gold, and rare earth elements, add another layer of complexity. Global demand for these resources is surging due to technological advancements, green energy initiatives, and industrial needs. However, extracting these minerals is fraught with legal and regulatory challenges. Many concessions are historically ambiguous, and national laws allow the state to nationalize or modify agreements at its discretion. Environmental regulations, often enforced inconsistently, introduce additional uncertainty. Mining companies must therefore engage not only with Venezuelan authorities, but also with international legal advisors to ensure contracts are enforceable and operations compliant. The risk is that a lucrative mining project could be derailed by regulatory shifts or contested licenses, transforming opportunity into an extended legal ordeal. Debt and international finance play a pivotal role in the Venezuelan legal ecosystem. The country has leveraged its oil and mineral wealth to secure loans from sovereign nations and private investors alike, frequently pledging future production as collateral. These arrangements are highly intricate, containing clauses that govern repayment, defaults, and remedies under a variety of jurisdictions. Disputes over these loans have already led to multiple international arbitration cases. Even slight deviations from agreed terms, whether due to political instability or economic mismanagement, can trigger cascading legal actions across borders. Investors and governments must therefore assess not only the value of Venezuelan resources, but also the legal exposure created by these pre-existing financial commitments. Sanctions imposed by foreign powers further complicate the scenario. U.S. sanctions, in particular, restrict financial transactions and energy deals, making compliance both challenging and essential. Any misstep can lead to fines, asset freezes, or civil and criminal litigation. Simultaneously, countries like China and Russia maintain a strategic presence in Venezuela, often through loans, investments, or long-term contracts. The convergence of these international interests creates a delicate balance, where legal obligations, diplomatic considerations, and financial opportunities intersect. Businesses must evaluate their actions carefully, as an agreement beneficial under one jurisdiction may simultaneously violate another, leading to legal exposure in multiple courts. Political instability amplifies the risk of legal entanglements. Venezuela has experienced decades of government turnover, policy reversals, and unpredictable nationalization practices. Each shift in governance can nullify prior agreements or impose new regulations retroactively. As a result, investors and companies must operate under the assumption that today's legally binding contract could be challenged tomorrow. This environment demands not only due diligence, but also ongoing legal oversight, risk assessment, and contingency planning. Failure to anticipate changes in domestic law can result in prolonged litigation, financial losses, or the forfeiture of assets entirely. International arbitration has emerged as a critical mechanism for resolving disputes in Venezuela's complex legal landscape. Cases are often litigated in neutral jurisdictions such as London, The Hague, or Washington, where arbitration panels evaluate claims against both corporate and state actors. These cases involve intricate arguments concerning contract validity, sovereign immunity, and compliance with international law. While arbitration can provide a pathway to resolution, enforcing rulings is often challenging when states refuse to comply voluntarily. Consequently, even victories in arbitration may not translate to tangible recovery, leaving parties entangled in legal uncertainty for years. The human cost of these legal disputes is equally significant. Ordinary Venezuelans often bear the consequences of stalled projects, frozen investments, and economic mismanagement. Infrastructure development is delayed, employment opportunities diminish, and access to essential resources becomes more difficult. Legal entanglements that appear abstract on a global scale have tangible effects on local communities, highlighting the intersection of law, politics, and societal well-being. This dimension underscores the importance of careful, ethically guided legal navigation. Stakeholders must recognize that missteps in Venezuela do not merely represent financial loss, but also have profound social and human implications. The combined effect of these challenges makes Venezuela a unique case study in risk management. The potential for massive financial gain exists, but it is inseparable from the likelihood of complex, multi-jurisdictional legal disputes. Businesses, governments, and investors cannot approach the country as they would a standard emerging market. The $3 trillion trap is as much legal as it is economic. Every contract, financial transaction, and policy decision must be scrutinized for its potential legal ramifications, often involving teams of international lawyers, risk analysts, and political advisors. Those who underestimate the complexity of Venezuela's legal ecosystem often find themselves unprepared for the scale of litigation and arbitration that follows. Moreover, Venezuela's situation has broader implications for global markets. Legal disputes over its oil and mineral resources can influence commodity prices, investment strategies, and geopolitical alignments worldwide. Arbitrations and lawsuits are not isolated. They ripple across the global economy, affecting the strategic decisions of multinational corporations and sovereign nations alike. Understanding these dynamics is essential for anyone seeking to navigate international business or diplomacy in regions marked by legal and political instability. Venezuela's case highlights the critical role of law in shaping global resource management, where legal miscalculations can produce consequences far beyond national borders. In conclusion, Venezuela represents a high-stakes intersection of wealth, politics, and law. Its $3 trillion in resources is unmatched, yet accessing that wealth is fraught with complex legal challenges that demand extreme caution, meticulous planning, and deep expertise. From oil and minerals to debt obligations, sanctions, and political instability, every factor contributes to a landscape where legal pitfalls are as significant as financial opportunities. The lesson for investors, corporations, and governments is clear. Opportunity cannot be separated from risk, and understanding the legal environment is not optional but essential. If you found this analysis insightful, be sure to like this video and subscribe to our channel for more deep dives into global crises, economic power shifts, and resource-driven conflicts. Stay informed, stay cautious, and stay ahead of the game.